Here we go. All right. And Maria and Sean, the stage is yours.
Perfect. All right, everyone, welcome. Before we begin, I would like to plug Sean. He recently just won a collegiate moot court regional. So that's why I've recruited him today. He's extremely knowledgeable about moot court strategies and pitfalls. If there's someone that can speak to those things, it is Sean. So I am going to let him take it away so we can start off. Welcome and interrupt at any time if you have any questions.
Great. Yeah, thank you very much, Maria. So this presentation is going to cover strategies and pitfalls of typical moot court arguments, some of which might be a little bit repetitive for you guys. You might know some, you might not know some, but we want to be pretty thorough here. So we're going to quickly overview what we're going to talk about, which is this. We're going to talk about the importance of clarity and what clarity actually looks like in substance. We're going to talk about presentation, responsiveness, and rebuttal, which in my opinion is probably the most important section of this. And then we're going to do an activity. All right. So yes, in that order. First, let's talk about clarity. The idea of this section, I think, can be looped back to the old expression of when you're public speaking. Tell the audience what you're going to tell them, then tell them what you told them, right? But in more of a specific order, okay? So first off, a messy argument in a speech is not an argument. It's just a mess, right? No matter how good your content is, there's something I want to drive through really fast, which is that without clarity, you kind of just lose. It's a losing condition, right? And moot court is inherently convoluted and confusing, but it's your job as an advocate to make it clear, right? Success in moot court requires clarity in your argument and deliberate clarity. Clarity is not something that will come to your argument without a significant amount of work, because this stuff is inherently confusing. Your argument can't just be throwing together points and hoping that the judges are knowledgeable enough or learned enough to understand it. Usually the judges are going to come in, they're going to briefly read a bench brief, briefly, if at all, and then they'll just start asking questions that come to your mind. They haven't read the cases, they've barely read the case packet, if at all, right? So clarity in that delivery is important. The question we then ask ourselves is, how do we do this, right? I'm beating a dead horse here at this point. The first thing to talk about is theme, okay? So every case can usually be reduced to one tension. That is to say, one little fight that the parties have between each other. Okay, now, of course, this is reductive, but for the sake of moot court, we kind of need to be reductive, right? There's 10 minutes, and we need to make the world a little bit smaller here. Okay, this phrase, this theme, can be made into one word or one phrase usually. And this phrase could be a weapon. Okay, it can be a real asset for you. And this phrase should be your theme. One example, or two examples, I suppose, is in abortion jurisprudence and really abortion politics. The themes are the right to choose versus the right to life. That one's very, very famous. In excuse me, vaccine debates, it's the difference between bodily autonomy and public health. Those are the themes. So identify a theme in your argument. Too often I've come across teams that don't really have themes. And if they do, it's not clear, right? You want to talk about, for example, the proper role of the court, privacy, equality, personal autonomy, something like that. You want the judge to walk away fully understanding your theme, not just some technical argument regarding jurisprudence, but more specifically, the overview, I guess, of your argument. For example, in my argument this year, in fact, it's an argument defending the Dobbs case, right? So the one which overturned abortion. Not my favorite case, but hey, you got to argue both sides, right? My theme for that case is that this case is fundamentally about the court interpreting the law, not creating it, right? It's about the role of the court. So that's what I repeat, but you don't want to repeat it too much. You just want to think of it as an anchor that you can come back to in answers and in certain sections of your argument that can help with clarity. And I have kind of rarely seen this on a lot of other teams. Like there's some teams that just don't do this at all. They just hop right into their argument. We're going to talk about that later, but let's imagine that you have a theme. Let's call it this case is about the intimate privacy of an individual in their own home or something, right? What do you do with it? What do you do with it? Well, Iraq, right? Anybody here? I mean, maybe quick show of hands. Are you guys familiar with Iraq? I don't want to beat a dead horse here. All right, McLean, classic. Okay, I'm seeing at least one shaking head. I'm going to assume with you guys with the cameras off, it's probably a mixed bag. So I'm going to cover it, but sorry if it's repetitive. I will cover it because it's covered repeatedly in a lot of pre-law areas. It's talked about in mock trial. It's talked about in any legal writing classes you'll take. There are podcasts and books written about this method. And there's a reason. It's because judges look for it. Okay, it is a specific formula which your argument ought to follow. And it is issue, rule, analysis, conclusion. Right? Some people go with a modified version of this called CRAC, C-R-A-C, conclusion, rule, analysis, conclusion, which is my preferred method. But honestly, it's not a massive change. Iraq is more prevalent though. Just to be clear, when we mean issue, we mean what's the topic. When we mean rule, we mean what rule jurisprudentially, right, within a case are you invoking? And then for the analysis, it's about applying that law, that rule to fact, right? Applying law to fact. And then for the conclusion, you get the idea. Right?
To my page. Besides this, it's okay.
No, was that a question or just a accidental mic being left on? No worries.
Errant mic.
Here.
Yeah, no worries. I will continue. However, been there. So let's look at a quick example of Iraq. Okay, I do want to emphasize this pretty much to death, I think. Because if you don't do this in legal writing, in brief writing, in your oral argument, I think you're much worse off for it. And there are too many teams that don't do this. So you want Iraq in your script. You want Iraq in your responses to questions. You want to Iraq everywhere. Okay, it's a formula that's a little bit of a catch-all. So this is an example from a brief for petitioners in this case called Carson v. Macon. And I'm going to quickly read it. And then we could talk about what in this or how this divvies up into Iraq. Okay. So Maine's exclusion, however, does not lack neutrality alone. Excuse me. It also lacks general applicability. The principle underlying the general applicability requirement is that the government cannot, in a selective manner, impose burdens only on conduct motivated by religious belief. Cited to Lukumi. Yet Maine's exclusion does just that. Yada, yada, yada. And it expands on that point. So I'm sure in your head, in your mind's eye, maybe you can picture where the Iraq comes into this, but let's walk through it anyway. Issue, almost as if it's a formula, which it is, issue comes first. Maine's exclusion does not lack neutrality alone. It also lacks general applicability. So the issue here is really general applicability, right? But you start with that. Start with introducing that topic just as you would in a topic sentence that your English teachers, tell you to write, and that's pretty. That's hit over your head like a million times. Rule. We can imagine this is the rule. Typically in legal writing, it's made in the form of a cite. You use exactly the words that the court used, and you put them in quotation marks. That also isn't particularly too complicated. In this case, it's a rule saying that the government cannot in a selective manner impose burdens on motivated on religious belief activity, really. And that's a case from this year's moot court case for collegiate moot court, sorry. And then we get to analysis. This is applying law to fact. I think that's best shown with this line right here. Yet Maine's exclusion does just that. It's textbook Iraqing right here. Okay, easy. Any questions there? I feel like that's not too crazy. Okay, cool. I cannot emphasize enough about Iraq. I think a lot of people see this and they're just like, okay, cool formula that I can follow. It's less optional than you might think.
Can I make one suggestion?
Yeah.
When you send out the this is Paul Lander, obviously. When you send out the slides for the people who are watching, because the people who are listening now, I think you need to define Iraq in the slides so people see that, because when you're saying it just very quickly, I think it's going over a lot of people's heads, especially people who are doing this for the first time, 9th graders, 10th graders. And so I think you need to spend a little bit more time just explaining what Iraq means and having definitions in the slide so people see it in a written word, so they can understand and follow along more what you're doing.
Yeah, before we send this out, we'll make those edits.
Also, we'll be providing the recording, so Sean's verbal analysis and explanations will also be there. And I think in the further slides, we have a couple more things coming. So hopefully it'll all be clear too. But good point. Good point.
So far, though, are there any questions about what Iraq really looks like? How it works?
Go back to that slide and just define each word so that so people can see it.
Absolutely. So here we are back to the essence of Iraq, just the basic acronym. When we talk about the issue, that's your topic sentence. You guys are familiar with that. When we talk about rule, we're talking about this specific legal standard that is invoked. In your guys' case, it might have to do with, I believe this year's case is a free speech case. So it might have to do with the clear and present danger speech, right? You might be citing, what is it, Schenck, to that effect? That might be the rule. In the analysis, you're talking about how that applies, how that rule in Schenck applies to this case, right? How that applies to, what is it, Chambers? I think it's Chambers. And then at the end, you're making your conclusion. You're making your position, okay? The one thing that I don't think I stressed is that this formula applies in the macro and the micro. It should apply throughout your argument, and it should also apply within points in your argument, I suppose. This example, which we covered right here, is a good example of a more micro application, right? Because you have the issue, the rule, and the analysis. No conclusion right here because in the actual brief, there's a little bit more analysis that goes on. It's mostly superfluous for our purpose. But this formula can and should exist in the micro or in the macro across your argument. Okay. Any other questions there? All right. So we have that Iraq. What do we do with it? Well, we kind of want to signpost throughout it. Are people here familiar with signposting? Just the general idea. Okay. So signposting is essentially providing cues about where your argument is headed next, right? It's essentially a sign on the road for your argument. It's really to help the lazy judge, right? Because if we're being honest, most judges are lazy. If a judge nods off and wakes up right as you signpost, you're going to want to know, or she would want to know, where you are in your argument. And signposting can take many forms, but each form is pretty important. The two biggest examples, really, ever, is saying on my first point and then saying that takes me to my second point. Those are very clear signposting. It's unambiguous. It's in basically everybody's argument. Pretty much everybody has that. But there are a lot of more minor ones that you really, really want to throw in there. Okay. Because you don't want to just be talking about a subject, assuming that the judges have familiarity with it, assuming that the judges know where that is in your argument, and assuming the judges know how that fits into your larger argument. You want to provide that context through signposting, right? Petitioner said that leads us to this topic. A big one in responses to questions are 2 points on that question, Your Honor. First, blah, 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 blah. Second, blah, 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 blah. At regionals this year, there were surprisingly a significant number of collegiate teams that weren't doing this, not signposting nearly enough. And to that effect, even a listener which is familiar with the cases can be pretty confused by their argument. So if you do that, or if you do this, you'll be at an advantage, I imagine, right? All right, with that, I'm going to stop screen sharing and hand it right over to Maria.
All right, let me screen share real quick so we can continue. All right, picking up right where we left off, we're going to talk a little bit about presentation. We didn't go through that overview slide, but as an overall, we went a lot through legal reasoning, especially with Iraq, which is extremely important in oral argument. And right now we're going to go over effective presentation, right? Because at the end of the day, moot court really is about a synthesis of effective legal reasoning and effective presentation. So what does that mean? I'm going to go through some pitfalls of what I like to call some negative contagious habits. By contagious habits, I mean these are habits that you might pick up from other public speaking activities, such as mock trial and debate, which are very common in high school and in collegiate level competitions. So first, avoiding dramatic flair, but still being dynamic. In a lot of activities, such as mock trial, dramatic flair is encouraged just because of the nature of the activity. Moot court's a little different in that you want to avoid that dramatic flair, but still maintain a dynamic tone and posture throughout. Because at the end of the day, you're not really reciting a script or a speech, right? What we want is a conversation between the competitor and the judges. So this is where striking that balance between formality and still being dynamic can come in really handy, but avoiding too much dramatic flair, right? At the end of the day, just be straightforward with your argument and open to questioning. And this is where that balance lies, really. Another convention thing is to never refer to opposing counsel as opposing counsel. Always referring.
Can I make one point about going back to the last thing you said,
especially
for the people who are doing it in the virtual tournaments. One of the things she's talking about, and it's true also in person, is if you're flailing around with your arms, first in person, they don't want you to do that in collegiate moot court, and almost ask you to have your hands on the podium, but if nothing else, just raising him a little bit. But you should know that when you're doing it in in virtual tournaments, there, hand flailing looks really odd because you're going in and out of the screen, and it's even more of a detriment when you're doing that. And that's also true in mock trial when you do it. So hand flailing is really problematic for everybody, especially in virtual tournaments.
Exactly. Thank you, Paul. That was extremely helpful. So yeah, an example of that would be hand flailing, a little bit too much theatrics. It takes away from the focus of your argument, right? So you want to avoid that and lean more into focus on the conversation that you're having with the judges. Again, never refer to opposing counsel as opposing counsel, always saying petitioner or respondent, just to maintain that friendly tone throughout the competition instead of the adversarial tone that comes with referring to the other side as opposing counsel. I've seen a lot of teams, even in collegiate moot court, do that. I've done that on accident. Just in general, not a good look. Refrain from doing that and always resort to counsel for petitioner or counsel for respondent. Pick and choose your battles, right? You have very limited time. You only have 10 minutes on respondent and usually 9 minutes on petitioner. You can't get through every single little thing pertaining to your side. So really picking what are the most important points that I need to get to, and what are some points that maybe I can sacrifice, some contextual things that I maybe can sacrifice that are not really too necessary for the judges to understand my argument. And just overall, this is a great tip all around, taking your opponent at their best and being classy at all times, right? This goes back to maintaining that friendly tone throughout the competition and not really cultivating so much of the adversarial dynamic that can sometimes happen in these activities. So a little bit more on courtroom
Can I
demeanor.
go back to one point that I think that's also with in terms of picking and choosing your battles in terms of very limited time? One thing that you're going to have to learn is that a judge, might have his be in his bonnet about something and continues to take you down a road and is burying your time. And at some point during the argument, you might, and obviously you're going to talk about this with your coaches, you're going to have to figure out at some point whether this point that the judge is just focusing on and just eating up a lot of your time is something that at the end of the day, you might have to concede, because once you concede it, then it allows you to move on to your next point. Because if the judge just wants to, just continue to question you, you're not going to get to any of your argument. And he's usually getting you on a point that is very likely a losing point, and you have to decide whether it's something that you can see, which is a very tough, thing to learn, but it's something to think about and work with your coaches on doing, because some judges, if they don't know the case, this is something that they think is the most important thing, and so you unfortunately you have to battle the things that the judges are asking you about.
Exactly. That's also a good point on saving time, which is smart concessions. Sometimes they can drag you through a rabbit hole, like Paul said, and you gotta realize when that rabbit hole really is not helping you and taking too much time away from your argument, and quickly go back. So helpful point. All right, a little bit on courtroom demeanor. Procedure matters. Don't take the small things for granted. Usually, a lot of the time, people really want to get to the meat of their argument and they overlook the little things, and they can end up losing a lot of points and missing kind of another part of the activity, which is paying attention to the small things, such as saying, Madam or Mr. Chief Justice, and may you please the court. This goes with keeping track of time regarding rebuttal and extensions. When you start your argument, just a small tip as petitioner, remembering to ask for rebuttal in the beginning. I have seen teams forgetting to do it, and after respondent finishes their argument, there's no rebuttal. The round is over and they lose a golden opportunity, which we're going to talk about why rebuttal is such a big deal that people also overlook in a little bit. And extensions, right? As Paul mentioned, sometimes a lot of justices can ask questions and you can find yourself in a rabbit hole. And sometimes that can happen when you have 10 seconds left in your argument. At that time, it's important to remember to ask specifically the Chief Justice for a time extension, right? In a round, the Chief Justice is the only one with the authority to grant that extension. I've also seen people ask the wrong justice, and the justices kind of look around the room being like, hey, I'm not the one that's supposed to give you a time extension. He is, or she is. So that's another thing to keep in mind. And just in general, formality, right? Even when you're not up there giving your argument, you are still working. You are still in a moot court round. So maintaining a formal and professional presence at all times, even when your opponent is giving their argument, is very important. So little things that I've seen happen is facial expressions. People make faces when counsel for petitioner, respondent, or opposing counsel is saying something that they disagree with, or is saying something that they're going to respond to in their argument or rebuttal later. I've seen eye rolls, I've seen sighs, I've seen just little things like that that are not really conducive to a formal environment. And this, again, even when you are giving your argument, goes to striking a balance between being formal and being conversational. Too much formality and too much professionalism can make you kind of stiff and make it so that it looks like you're reciting or regurgitating a script. So it's all about striking that balance between being formal and professional and still having a conversation with the judges.
Maria, do you want to quickly go through maybe examples of like how to ask for a rebuttal, how to ask for a time extension, just to cover our bases on that?
Yeah, absolutely. So how to ask for rebuttal is petitioner before you begin the round would be Madam Chief Justice, before we begin, we would like to reserve 2 minutes of our time for rebuttal. And 100% of the time, the Chief Justice is going to say granted. And let's say in a question scenario, let's say I'm giving my argument and I'm about to conclude, right? And I'm saying, therefore, the statute violates the 14th Amendment to the Constitution. And for these reasons, we ask the court to reverse or affirm. And then let's say Sydney asks me a question right as I'm about to say, we ask this court to reverse. I would look at the Mr. Chief Justice and say, Mr. Chief Justice, may I please be granted a brief time extension to answer the question and conclude? Chief Justice is going to say granted 100% of the time. I've never run into a scenario where they say no. Little things like that, right? That type of procedure. So yeah, does that help clarify things?
Yes. Great.
Awesome. All right, now I want to go through something called weaponizing silence in the presentation aspect, which is making the best use of pauses throughout your argument. So what do I mean by that? Why would you do that? And how do I do that? Pauses are more than a tool to buy you time when you forget where your argument is or when you're lost in your argument. Pauses can be conducive to persuasion. They can help you with delivery. They can give you time to recall your argument. They can give you emphasis on a point you really want to drive home. They can reflect confidence and competence, and they can help you regulate speed throughout your argument. Pauses are very, very, very important, and a lot of people overlook that. So a little bit on persuasion, right? How can pauses and silence help with persuasion? And what even is to persuade someone? Like, how do you persuade someone? Hint, you don't, technically. People persuade themselves. As you're giving your argument, the judges are going through the rationale in their head, being like, am I convinced of this? Am I not convinced of this? As a judge, you're doing one of two things. You're either listening to counsel's argument or you are thinking about what the heck counsel just said. What does this have to do with silence? It really reflects on a big advantage of pausing, is that it lets people reflect on your last words. That pause in your argument allows the judges to first try to understand what it is you just said, right? Sean went through how Moot Court can be very convoluted, and it's your job to make it simple and clear. To vet against their own knowledge, right? Judges have read the brief, maybe they've read the case. They're comparing what you just said to what they know about the case and what they know about the precedent and what they know in general. And if what you're saying is good to adopt as the court, right? Do we want to adopt this as the law of the land, basically? That is why silence can be so effective. And silence can be a chance to give you emphasis on your argument, to emphasize your last point. Instead of just moving on and running through the entirety of your argument, you give judges time to marinate on what it is you just said. It can also give you confidence and competence. A lot of the times, speed reflects insecurity. It's really important to be comfortable with sitting in awkward silence sometimes, because it might happen throughout your argument. And again, speed reflects insecurity. If I am speeding through what I'm saying and trying to get through it as fast as I can, that gives the message that I'm just trying to get through it, and because I don't know what it is I'm talking about. So I'm trying to get through it so the judges don't even have an opportunity to ask me questions or something like that. And
Maria, can I just say one thing that's also important for speed? Speed is at the beginning of your argument, everybody who's listening, it's really important because this is the first time the judge is hearing your voice. And so that judge doesn't know your cadence, doesn't know how you speak, whatever. So when you're going through your roadmap, it's really important to not speed through it and enunciate clearly, so that the judge, first of all, it gives you a chance to develop some intimacy with the judge and start a conversation. But it's also a chance for the judge to hear how you speak and hear the words and whatever. So if you speed through the first 2 minutes of your argument, which is really important, the judge is just not getting a clear sense of who you are and what your argument is about. So it's really imperative at the very beginning to make sure you're not going too fast. And for the people, just so you know, when you get nervous, one of the ways that people get nervous is they speak too fast. And so you have to understand that that's going on. So you have to just consciously just try and slow down to go through that beginning argument so the judge hears it clearly.
Yeah, absolutely. Thank you, Paul. Just as a little preface, everything that you've said is extremely that is so true, exactly. And this is our second workshop, or this is everything that we've been talking about here is also a little preview of the next workshop we're going to do, which is going to touch specifically on public speaking and all of those other little things that go with presentation. So yeah, this is a good foreshadowing to that as well. All right, I believe we have a question in the chat. Not sure if this was mentioned. Oh, Sydney. Yes.
Oh yeah, yeah,
exactly.
it was just good point being made in the chat as well.
Awesome. All right, now we're going to cover a little bit of entertainment as an approach to speaking. Whether we like it or not, at the end of the day, when we're giving our arguments, we need to keep the judge's attention. You are fighting for a judge's attention against your opponents and boredom. So how do we do that? Think about it like this. If what you're saying bores you, it bores the judges. So this goes to using filler words and saying buts, or using even filler sentences when you forget your argument or something like that. And giving unnecessary context. If it's not imperative to your argument or to your reasoning or to establishing Iraq within your argument, and if it's boring you, it's probably going to bore the judges, and that's going to be reflected in your performance. Again, nothing too flashy. This isn't a carnival. You don't need anything too flashy, right? Remember, the dramatic flair avoided. This is more about the way in which you're presenting your argument and avoiding the filler and the unnecessary context. I'm going to touch a little bit on confidence, and confidence is manifesting success. We've all heard the saying, confidence is key. So the tone and the attitude throughout the argument is, no matter what happens, no matter if you answer a question maybe a little bit wrong, no matter if you deviate from your script, and no matter even if you accidentally switch sides for 10 seconds, you planned for it, right? This is key. You have to act as though you plan for it. Usually a lot of the judges are not going to notice that mistake. So saying, I'm sorry, Your Honor, pausing and excuse me, Your Honor, letting the mistake show is going to count against you, because a lot of the times judges didn't even notice the mistake. So going off of that mistake and going right back and picking up where you left off, no matter what happens, you plan for it. That's a very, very good slogan to maintain throughout Moot Court. Okay, do we have any questions? I've covered a lot of stuff. I want to pause a little bit before I go into responsiveness and rebuttal. No questions? Okay, awesome. I'm going to move on. Now we're going to cover responsiveness and rebuttal, last section before we go through our activity. So answering questions 101, right? How the heck do I answer questions that the judges are going to throw at me when I'm giving my argument? First of all, be direct. Yes, Your Honor. No, Your Honor. Yes, Your Honor, but. No, Your Honor, but. It depends. You need to first answer the judge's question, especially if it's a yes or no question. A lot of the times competitors get these questions and they go straight into explaining the precedent and their reasoning. And at the end of the day, you can speak for 30, 45 seconds, but you didn't really answer the question. So this is really, really important. Also, having structure. If you have multiple explanations in your answer, enumerate them. Yes, Your Honor, 2 points to that, Your Honor, first and second. Creating a roadmap and outlining your prongs within answering questions makes that answer 10 times more clear. And that is going to be reflected in your performance at all times. And also get to the heart of the question. What is the judge really asking? A lot of the times, answer to questions can be very dodgy, and they don't really, it gets across the message that the competitor doesn't really understand the question. And if, hey, that's really the case, it's better to ask, Your Honor, may you please clarify your question? And they will gladly do so. Cite meaningful precedent. Don't just give an answer and move on. Where are you getting that standard from? What case are you getting that standard from? What are you using to support your answer in particular? And anticipating the follow-up question is also really important. Ask yourself, if he's asking this, what does this speak to the doubt that the judge has in his mind? And try to answer that doubt in general in your answer to the question. This is a really important section. I believe answering questions is at the heart of moot court. So if you guys have any questions, please interrupt me as always and ask. All right, so responsiveness goes with being respondent. If I am counsel for respondent, how do I do that? How am I responsive on respondent? So being respondent is really not just about giving your argument. This is an opportunity for you to respond to petitioner, and a lot of people take that opportunity for granted. This means that you really need to listen carefully to petitioner's argument and show the judges you did. Petitioner claims XYZ, or petitioner errs in the reasoning of XYZ. Referring back to petitioner's argument and directly responding to it as respondent means that you're actually fulfilling the role of being respondent and being responsive to what petitioner has said. Being respondent really is, I mean, this is a moot court tip in general, but especially as respondent, it's all about being adaptive. This is an idea we're going to talk a lot more about in our public speaking presentation, but ideally you're not married to your script, right? You're not just trying to recall your script at all times. Being respondent means tweaking your argument here and there, often in meaningful ways to respond to what petitioner said. If one of your prongs is completely irrelevant to what petitioner has said, then you are in a good position to change that prong and adapt the prong to what petitioner said to make sure you're responding to what opposing counsel said. Okay, cool. And finally, rebuttal on responsiveness. Rebuttal is short. Make it count. This is petitioner's last chance to argue before the panel. You're getting the last word. Rebuttal is a lot about time management, so organization is key. When you're rebutting, you need to make sure that you're covering both issues, right? Dedicating a minute or so to issue one, dedicating a minute or so to issue two. A lot of people fail to be organized and fail to time management, engage in time management in their rebuttal, and then they just end up covering one issue and the other issue just goes completely unaddressed. And this goes with when beginning a rebuttal. First, your honors, I'll be addressing issue one, and then addressing it, and then signposting and saying, then I'm going to be addressed issue two, whatever that is. Rebuttal is really not time to introduce new arguments, claims, or evidence. No, you only have 2 or 3 minutes to make your point. It's all about responding. So whoever is giving a rebuttal needs to especially listen super carefully to what respondent has just said. Here you are responding to respondent. What is the most crucial aspect of your opponent's argument, and how are you going to address it in 1 minute? You can't possibly address everything they've said, right? So pick the one point or one of the points that their argument hinges on and try to attack that as best as you can. So yeah, this is our rebuttal overview. Any questions on responsiveness?
And one of the things that the judges will hate is that if you have a canned rebuttal that you've written that and you're reading it and it's just sort of reiterating your points there, the judges are going to mark you down because one, you're just it sounds canned and the judges will know that, and two, you're not really addressing yourself to what the opposing counsel, even though you're not supposed to use that word, has said, and so you have to make sure that it doesn't sound really rehearsed, and so that's really important. And secondly, I always tell my kids that at most you're going to be able to get 2 points for issue one and 2 points for issue two, and if you try and cover anything more, then you're going to run out of time, and you're not going to do either of those 2 points for each side, for issue one and issue two well. So don't think about doing anything more than that.
Absolutely, Paul. Yes, at the heart of rebuttal is rebutting, responding to what Counsel for respondent has just said. So if your scripted rebuttal is not conducive at all to what respondent has just said, the judges are going to notice that, right? If you just zone out during a respondent's argument and doesn't really respond to that, then it's going to show. All right, everyone. This is time for our activity. Show what you know and apply what you've learned. Most of all, don't be afraid to make mistakes. We're going to do a little brief activity. Right now, take what you've learned or what we just talked about themes and about structuring your argument, and maybe break down the introduction. Sean, what do you think? We have how many participants? 14 around. Do you want to do breakout rooms or do you just want to do like a general?
We could probably benefit from breakout rooms.
Absolutely. All right, let me make the rooms.
Yeah,
When we
at
say
least 2, maybe 3. What do you think?
I think we can divide it into 3. Let me just make the rooms really quickly. So basically what we want to do with this activity is break down the introduction based on everything that we've just covered. This is an introduction from a collegiate moot court argument from last year's collegiate moot court case. It's about the 8th Amendment, but you really don't need to know the specifics. Just think about the structure. What do you like about this argument or this introduction, and what do you not like about it? Maybe what is missing from it? How could it be organized more effectively based on everything we've talked about? Does it convey a theme properly? And is the order of the introduction and the theme and whatnot appropriate? So, yeah. Sean, did I forget anything about introducing the activity?
No, I think we're all good.
Awesome. Let me make the rooms. Awesome. All right, everyone. I think we have everyone back from the breakout rooms. So how did you guys analyze this introduction? What are some of the structural things that you saw that they did well? What are the things that they didn't do so well? Maybe some things that are missing. We had a lot of good insights in our breakout room, so I just want to hear your guys' thoughts. Please share.
Well, for our breakout room, we noticed a few procedural things. First, when they state that there are 2 reasons why the court should rule in their favor, they don't state those 2 reasons. And second, they put the theme at the very, very end of their intro, and that's not very helpful because this is just your intro. This is not your argument. You're not supposed to get into substance here. You're supposed to simply get your theme out there, get your basic overview out, and then begin your argument. And if you put your theme at the end, then you're not explaining your view on the case until the end of your intro. So those are our 2 big things.
Great point. Exactly. You're not really establishing a theme at the beginning, right? And the theme is supposed to guide or put it in the judge's head and guide the entirety of your argument. So doing it at the end of the intro is really not that effective. And you're right. The 2 points are missing. All right. Any great insights? Thank you so much. Any other insights?
We sort of talked about as well. It's not necessarily a huge issue, but I think it could also be possible to sort of make that theme sentence a little better, right? This case is about the culpability of juveniles and how they should be treated in our society. If you sort of include the sort of 2-sidedness of that issue, right? To sort of be like, here's where we stand. And so it's like Sean was mentioning earlier with how the anti-vax issue is sort of between the issues of bodily autonomy and public health, right? If you had some sort of similar thing for this issue, it might make that sentence a little bit more compelling, although it's not completely necessary.
Yeah, for sure. I think, Sean, do you want to speak a little bit more to that?
Yeah, I think maybe I could speak to that in the form of a little bit of a story. So a couple of quarters ago, because UC's on the quarter system, I took a class called about public speaking, right? I needed it for one of my general education requirements. And it was a pretty easy class because it was teaching some rudimentary stuff, which I have no doubt all of you basically already know. And there were some gripes I had with the class, whatever. But there was one insight that I actually really liked. And the point was that most debates, most speaking debates, most written debates come down to a very simple tension, which is often the good versus the necessary. the good versus the necessary. There's typically one side which articulates an ideal vision. Maybe it's more idealistic, maybe it's more outcome oriented, saying this is something that is good, right? But then there's a side that's saying, sure, that's good, but this is necessary. Take wars, for example. Nobody thinks wars are good. So the good side would be no war, anti-war. That's the good side. Morally speaking, most people have a consensus on that. The necessary side, however, is that we have to go to war. We don't have a choice. National security. People got to die. It's necessary, right? And I think that applies to pretty much everything. I think that definitely applies to your guys' case this year. And it's something you might want to keep in mind with your themes, because it's the good of having less like violent speech versus the necessary about what kind of system you need. At least that's my understanding of it after briefly reviewing it. So maybe keep that in mind for themes.
I think another way of explaining that is that what people have to understand is that in constitutional law, the court is constantly having to balance constitutional rights, and so that when you're thinking about your issue there, you have to understand that the other side has equally strong constitutional right that they're asserting, and you have to convince the judge that under these facts your constitutional claim should succeed versus the other constitutional claim, and judges have to Supreme Court judges and other judges, federal judges, have to constantly do that. But when you're thinking about your argument, you have to think about what constitutional claims is the court balancing and why you should win, why your claim is better. And basically part of it is going to come down to that the facts are convincing the court that the facts under this case are more in line with your constitutional claim winning.
Absolutely. Thank you, Paul, for those insights. All right, so let's compare this other intro, and this we can just do in this main room, right? Let's go through this intro. What are the differences that we see between this one and the last one? I'm going to read it out. Mr. Chief Justice, and may it please the court. This case is about the culpability of juveniles and how they should be treated in our society. The state of Olympus violated Willem Dinoff Jr.'s Eighth Amendment right to be free from cruel and unusual punishments by sentencing him to prison for a term that exceeds his life expectancy. This court should reverse the Olympus Supreme Court's decision for two main reasons. And first, here we have the first reason. Then second, we have the second reason. What are some main differences that we see between this introduction and the last one?
Well, you start off by immediately offering a theme and trying to paint a picture for the case. And in addition, you actually do list your outline for your argument. You simply don't state there are 2 points and then leave them out. So you explain to the judge the broader issue at stake here, and then you also give them a glimpse of your more specific legal arguments.
Absolutely. Great insight. Exactly. You start broad and you go narrow from there. Way different than the last one, right? The last one was kind of really messy in that it did the opposite, and it really did not properly convey the theme of your argument. All right, what some more insights we have?
One more smaller thing I noticed was just the aspect of like eloquency and formality in this one compared to the other one. Like just even the small "may it please the court," like to me that makes it more formal, more of a professional relationship with the judge. So I think that's important.
Absolutely. We always need to say Mr. Chief Justice or Madam Chief Justice, and may it please the court. Forgetting that is a big no-no for courtroom demeanor. So great insight.
There's also signposting in this one, which is lovely.
Yes. Incredible. Okay, I'm going to go over this one then real quick, right? First, we have proper introduction. You address the Chief Justice and you say, Mr. Chief Justice, and may it please the court. Well, already way different than the last one. we have a theme, and we have a theme in the proper place of the argument, right? We have signposting and organization. You actually say it should be reversed for two main reasons, and those reasons are clear with your use of the words first and second. Clear, it's concise, it's simple, organized, establishes a theme, and it has proper formality. So, all right, this is a way better intro.
Yeah,
right.
the other thing very quickly for people who are listening to this is that this is about as long as you're going to get before you start getting your question, your questioning. And so it has to be, if your roadmap, and this is basically also, you can consider your roadmap, especially about the two main reasons there. The roadmap can't be so long that because remember, you have 10 minutes there, and so your roadmap, should be no more than a minute, 90 seconds here, a minute to 90 seconds there, and so it shouldn't be any longer than this, because you're gonna get interrupted, and your roadmap is then going to seem like it's very disjointed. So it's got to be concise enough to fit into that minute, minute 15 seconds.
Absolutely, yes. Keeping it short, clear, concise is always important. Going through your intro within a minute is usually the ideal timeline. All right, now we have, this is a first prong that would follow from that intro. We're gonna go into breakout rooms again and ask ourselves, how could this first prong be better? Specifically pertaining to the organization of this first prong and Iraq, right? Where do we apply Iraq? How do we apply Iraq? Where is Iraq missing? Is it applied? Is it not applied? So yeah, I'm gonna open up the same breakout rooms again, and then we're going to reconvene in about 3 minutes in the main room. All right, I've opened all rooms.
Hello. Let's see. Let me pause this.
Have everyone back? Oh, I apologize. Okay, awesome. All right, what did you guys talk about in your breakout rooms? What do we think of this first prong? Do we like it? Do we not like it? How's the organization? Do we see Iraq?
I know in our breakout room we brought up sort of Iraq structuring, how there's how the introductions sort of like that already sort of is the I in Iraq a little bit, and so we're mainly focusing on the RAC here. And I think that there's some misordering of sentences happening. So like it doesn't really lead with the rule as much, which is the court's holding in Graham. And so it almost might make more sense to move that first sentence about the insignificance of the technical like language of his sentencing to the rest of the analysis, and just to shift a few things around like that.
Absolutely, couldn't agree more. And that is a good catch. The issue in Iraq was actually introduced in the introduction, right? The issue that we're dealing here with today was already in the intro. So here we're actually looking for the rule, the analysis, and the conclusion. Incredible. Do we have any other insights from a breakout rooms? No? Okay, no
Well,
problem.
I had, McLean, you had a couple of points, and yeah, you had a couple points. I think you could share that with the group.
Absolutely, thank you. I didn't want to dominate it at all. So a couple of things that we noticed. First, again, in this first prong, they don't really state what the prong is at the beginning, and that would be very, very helpful if you're discussing, make your points extremely clear, even though you've already summarized them in the introduction. In order to help the court stay with you, you need to keep repeating what point you're on throughout your speech. So they don't state what the point is at the beginning of this paragraph. Second, when they mention by these two principles, it's completely out of order because the two principles are stated earlier in the paragraph. And it doesn't follow the Iraq formula, because that would be you give your argument, you bring in a Supreme Court precedent to support it, and then you explain how it applies to your case. I can't even say this order is in reverse because it's just not in order as a basic matter of grammar. So we noticed quite a few problems. The only problem is it took us a long time to figure out what it was saying before we could even start to adjust it.
Absolutely. This is not following Iraq at all. Was that an insight? Was that? Wait, Yanni, did you unmute yourself, or maybe did I miss it? No? Okay, no problem. But absolutely, and this actually brings us into the analysis of how a better version of this prong. Let's compare.
Well, going back just to, could you go back to the last slide for a second there? First off, you don't, it was not sentenced to life without, but this is not significant. Why are you starting off a paragraph by saying that what I'm talking about, the first point is not significant? If it's not significant, why are you talking about it at all? Versus whatever you want to, and be more direct. Whatever you want to be talking about should be your first sentence, and not saying something that I'm not going to talk about is not there. If it's not significant, you shouldn't be talking about it at all.
That's we did talk about that a little bit in our breakout room, but I want to see if were you going to say that point about what I just said?
Yeah, I just wanted to mention what we talked about. I think I agree that it's sort of phrased poorly in that it gives the impression that the entire point is insignificant, but I think what they're trying to say is that the technical language of the sentencing isn't what matters. Instead, it's the fact that practically it serves as a life sentence, right, to lead into the rest of their argument. But I do think that leading with that sentence, not only does it not follow Iraq, but it also just it gives off the impression that the whole issue is insignificant, when really they're saying that this one part of it is not the thing to be focusing on.
Absolutely.
True.
Exactly.
And I'm sorry, and one quick thing, I was just thinking about that point too, also to Mr. Landau's point as well. It would still be bad if it was a brief because it's not written in proper English, but it would be slightly better if it was a brief because you could then read down 2 more lines and understand what they mean when they say it's not significant. Whereas in moot court, you might get interrupted at the end of your first sentence right here, and the court will not know what you're going to say beyond that. So really, your first sentence of any point, the court should just be able to hear that and immediately know what your argument was. They shouldn't have to guess and wait halfway through.
Exactly. Beautifully said. Beautifully said. Right. This is leading the bench to play a lot of guessing games. Right. The insignificant point. It's like, the way this is phrased is trying to point out that the sentence between a life without parole and life with parole for Denov here is actually a distinction without a difference. But it's starting off with that is not really following Iraq whatsoever. It's asking the court, it's inviting so many questions because it's asking the court to play so many guessing games. So with that, let's break this down into a better prong. Let's compare, right? Onto my first point. We have signposting. This court has already recognized the significance of the proportion of one's life spent in prison, as well as the diminished culpability of minors due to their immaturity. These 2 principles laid the foundation for the court's holding in Graham, which held that life sentences without the possibility of parole for juveniles are unconstitutional when homicide is not involved. The trial court did not sentence Denov to life in prison without parole, but this distinction is not significant. Denov's sentence is equivalent to a life sentence under the court's 8th Amendment analysis. Denov's first chance at parole would come when he's 65 years of age, more than a decade beyond his life expectancy. This is a virtual life sentence and is the equivalent to a life sentence without the possibility of parole. So how is this better? right? Some quick insights before we break this down.
I would say that this does a much better job of clarifying where that insignificance is and not making it seem like it's the entire overarching point of this section, right? To instead clarify partway through the analysis that the distinction is what's insignificant as opposed to the issue as a whole. It makes this sound way better.
Couldn't agree more. Absolutely. Yes, exactly. So much more clear what the difference without the distinction is and why it's important to the analysis.
I think the first four words are also really like, well, it's not a big thing, but I definitely think it's something that is overall structurally really important. Like just saying on my first point allows the judge not only to kind of look at or like visually look at your speech, but also kind of like stick with you as you're going down this argument.
Exactly. It is so when you're starting your first prong, it is imperative that you say on to my first point or something signposting saying that, hey, I'm about to start my first prong. Incredible. Absolutely. Right. So let's break this down in terms of Iraq. Signposting. We have signposting. This is, oh, sorry, I just got a message in the chat. Signposting. Crucial. You cannot start a prong without indicating that you're actually starting out that prong. We have the rule, right? This is the, I believe, already recognized that the issue was actually introduced in the introduction. We have the rule that we're dealing with, right? What has this court already said? What are the two principles that we're talking about that the court has already laid out in Graham? And what was Graham's holding, right? And then we have the analysis. How does that holding apply to this case? Why does the difference between a life sentence without the possibility of parole and a life sentence with the possibility of parole, what is the role that this difference is playing in this case, and why is this difference not really relevant to the case, right? And how does this apply to Graham? This is the analysis. And then here we actually have a conclusion. Therefore, this sentence is unconstitutional under Graham. This is following Iraq. This is proper signposting. This is organization. Way, way different than the first prong that we had before this one. All right. Do we have any questions, any more insights before we conclude?
I would just, in terms of the rule, I think that you need to be doing this a little bit more directly because it's just very wordy. And so on my first point, this court in Graham held get you into your point a lot faster than you went back to the slide there. So I think that you could think about trying to combine those two sentences together into one, or at least just getting Graham into the first sentence there, so that the court because the court will know that you're talking about a case. And so when you've talked about, this court has already recognized significance of that, whatever, without a case citation, I think this court in Graham, blah, 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 at least the judges will know that you're talking about a case versus just, some, isolated principle. And I think that would help, order your thought process on those two sentences and getting Graham a little bit more upfront.
Absolutely. Saying simply the sentence, under Graham, this court held XYZ, it really would help clarify this prong. This goes to show you can always perfect your prongs according to Iraq more and more and more. You can always make it clear, even if you already think it's clear. You can take it one step further and explicitly say that to the judges. Thank you so much for making that point, Paul. All right. Do we have any other insights? No? Okay. All right. Have any questions? Feel free to ask us anything. This was our workshop. Thank you so much for attending. We hope this was helpful in giving a brief overview for Moot Court strategies and pitfalls. Thank you so much, Sean, our guest speaker for NAMC. Thank you for taking the time to come and teach us all of these valuable insights on Moot Court. And thank you so much for everyone for participating so thoroughly. We really appreciate your presence and your engagement. And we hope this was helpful. Yeah, do you guys have any questions?
No, but thank you so much for hosting this. I really enjoyed it and learned quite a bit. Thank you all.
Awesome. Thank you for coming.
You guys have any questions? I and we will stick around to answer them, by the way.
Yeah, absolutely.
Other than that, please enjoy your Saturday. We'll see you at another workshop, hopefully, in the new year. And also, if coaches have any questions on registration, we can get to that as well. I'll also stop recording in case that's scary for people to ask questions. But yeah, thank you all for coming. Have a wonderful Saturday. Stick around if you have anything else.